Ladies and gentlemen, welcome to the Atlantic and the National Constitution Center's second annual Battle for the Constitution panel. During last year's panel, those of you who were here will recall, we had Senators Chris Coons and Jeff Flake on the day that they were trying to prevent the Senate from blowing up during Justice Kavanaugh's nomination hearings. Today, as soon as we announced the date of the panel, House Democrats decided to impeach the president. If you're invited for next year's panel, I suggest it may not be safe to show up. One of the great benefits of last year's panel was that it was so successful that the Constitution Center and the Atlantic decided to work together to launch today a thrilling new web project called The Battle for the Constitution. And over the next year, as Jeff Goldberg explains in his editor's notes, we will be convening the leading thinkers of all perspectives, conservative, libertarian, progressive, and idiosyncratic, to discuss not political issues, but constitutional issues, to illuminate the constitutional clashes that are at the center of the news and have pervaded American history. And we're so excited to share with you this launch panel, 3 of our distinguished scholars, to model for you what it means to discuss issues not in political terms, but constitutional terms. In other words, asking not what the government should do, but what the Constitution allows or forbids it to do. And by putting that constitutional lens on all of the questions in the news, we believe we can elevate the country above some of the partisan rancor that is transfixing the nation and help illuminating the underlying constitutional stakes. We have to jump right in. Of course, the first question will involve the constitutional dimensions of impeachment. And the way to start our homework for this important class is to consult the National Constitution Center's new and upgraded interactive constitution, which is linked on the Battle for the Constitution site. This phenomenal educational tool brings together the top liberal and conservative scholars to write about every clause of the Constitution, describing what they agree about and what they disagree about. So I can look to the impeachment clause, and I can find our 2 scholars with a 1,000-word statement about what they agree the core meaning of the clause is, and also what they agree is open-ended. So I'm going to start with that, because you can be assured that every word in this joint statement is accepted by scholars of both sides. And after beginning with the text of the clause, which is crucial in Article 2, Section 4, and says that the President, Vice President, and all civil officers of the United States shall be removed from office if convicted of treason, bribery, or other high crimes and misdemeanors. The scholars go on to say that although the framers decided to leave out a punishment for maladministration, which was Madison's proposal, and they took out the language about corruption, nevertheless, debates remain about how broad or narrow the clause is meant to sweep. And in particular, the scholars say that those debates include: can a government official be impeached and convicted for innocent mistakes, or must they have bad intentions? Is it sufficient to justify an impeachment and conviction if a government official commits acts that are disgraceful, contrary to the trust and duty of their office, or degrading to the honor of the United States? That's all language from the founding era. Or can impeachment only be justified when an official has committed criminal acts? And finally, do high crimes include only criminal offenses for which one could be prosecuted in a court of law, or can they include other forms of misconduct? Quinta, start us off with this crucial question as you analyze the text and history of the impeachment clause. Do you believe that the president's conduct in his conversation with the president of Ukraine, given the facts that we know now, would meet the framers' understanding of treason, bribery, or other high crimes and misdemeanors?
Yes. Do you need more?
Yes, one or two. Tell us why.
Not only does it fit that definition, I think it's actually a paradigm of what we might look to as an impeachable offense. Charles Black, one of the great constitutional scholars who's written about impeachment, in his case he was writing in the context of Watergate, wrote about impeachment as really focused on mitigating the abuse of power on the part of the chief executive, particularly the abuse of power for personal gain at the expense of the country, something that's not in the best interest of the country. He uses this wonderful phrase, something that's obviously wrong in itself to any person of honor. And I think if you look at the transcript that's been released, obviously we don't yet have all the information. There's still this whistleblower complaint, but I would argue, reading the transcript in context of everything that we know from news reports, it really seems that the president was attempting to pressure the Ukrainian president, Volodymyr Zelensky, to provide derogatory information about Vice President Joe Biden and his son Hunter. I would say, first off, that's not only a use of the president's foreign affairs power under Article 2 for personal gain, as opposed to the betterment of the country, but also that it's a gross civil liberties violation of Biden and his son. You know, we, in part because of actions taken by Richard Nixon, we bind our law enforcement agencies and the CIA as well very tightly in terms of what they can and can't investigate and what processes they have to go through. And the idea that a president would reach out to a foreign government, sort of go around those normal processes in order to try to find derogatory information, I think really rings very, very similar to what President Nixon was accused of in the articles of impeachment against him.
Thank you so much for that. You mentioned Charles Black. As it happens, his grandson, Robert Black, is a senior fellow in constitutional studies at the National Constitution Center. And I asked him to do a memo on the arguments for and against impeachment. And one of his conclusions was that the case that the president violated the criminal campaign finance laws is not clear because it's not obvious that the withholding of aid or even the possible benefit in the election was a thing of value as technically defined in the campaign finance statutes. John, if you conclude and others conclude that the president did not technically commit a crime, do you still think that he could be impeached for high crimes and misdemeanors? And do you think that this conduct meets that standard?
Well, so I have to respond to what Quinta just said. There are two things that she said that I agreed with, which is that abuse of power can constitute an impeachable offense, and that we are going to learn more facts in the days ahead. I mean, this is largely an issue that is left up to the House and Senate. There is no role for the judiciary in this process at all, other than if the president is impeached in a trial, the Chief Justice presides over that trial. So there's no role for the Senate gets to determine itself for legal reasons or political reasons what constitutes abuse, and they can set whatever procedures that they want to. I think it is quite a stretch to say, based on just the transcript that was released today, that we are anywhere near that threshold. There was no threat implicitly or explicitly to withhold aid from the Ukraine government during this call. It is even unclear when the president says to President Zelensky, look, we want you to look into this, whether he clearly mentions Joe Biden and his son Hunter. I'll get to that in just a moment. But he also mentions Bob Mueller, who had just testified. He mentions CrowdStrike. So in the context of that call, Bob Mueller had just shut down his investigation. Attorney General Barr had just announced that he was going to initiate his own investigation, which is ongoing, into how the Trump investigation began in the first place. And it actually seems to me that the mentioning of CrowdStrike, which is a company that was involved in the investigation of the hack of the DNC, there were a lot of rumors that the Ukrainians were involved in that hack, that in all likelihood what he was referring to in terms of conducting an investigation was not so much an investigation against Joe Biden and his son Hunter as much as it was an investigation into how the investigation of his campaign began. With respect to Joe Biden, I'm not excusing what the president did. He often acts in an intemperate manner. But, look, let's be clear. When Joe Biden was the vice president of the United States, the Senate had approved $1 billion loan guarantee. He went to Kyiv, Ukraine, and said, I am leaving in 6 hours, and you are not going to get that $1 billion loan guarantee unless this particular prosecutor named Smokin is fired. Smokin had initiated an investigation against an energy company that had just appointed Hunter Biden, who has no experience whatsoever in the energy field, to its board, and Hunter Biden was paid $1.6 million over the next 16 months. Now, that is troublesome. Now, the Congress can do whatever it wants to, the Ukrainian government can do whatever it wants to, but I think that it is very unclear from what we know now. I think we are at the beginning of an impeachment process. We may be far from the end. There may be other facts that come out, but based on this transcript, it's up to Congress to decide whether to impeach the president. As I say, it's largely a political process, but I don't see it, and I certainly do not see the Senate being anywhere near having 2/3 of the senators required to throw the president out of office.
Thank you for all that. I hear you say that there was no explicit quid pro quo, and there's lots of factual disputes about whether or not there was corrupt motives, and for those reasons, even if the president can be prosecuted for non-criminal offenses, you don't think this meets the standard. Martha, give us some historical context, and I do want to read some striking quotations that Robert Black found from James Madison about their specific concern over foreign intrigue in general and foreign influence over the president in particular. George Mason, the great anti-federalist who opposed the Constitution because it contained no Bill of Rights, said that shall the man who has practiced corruption and by that means procured his appointment in the first instance be suffered to escape punishment by repeating his guilt? Madison says the president might pervert his administration into a scheme of perculation or oppression, and he might betray his trust to foreign powers. And then Federalists 2 through 5 are all devoted to the fear of foreign force or influence, and Hamilton wrote that nothing was to me more desired that every practicable obstacle should be opposed to cabal, intrigue, and corruption. The most deadly adversaries of Republican government might have been expected to make their approach from more than one quarter, but chiefly from the desire in foreign powers to gain an improper ascendant in our councils. Martha, there's much to say about the history of impeachment, both from the founding era and also from the Johnson era, but what can that history teach us about our current vexations?
I think the first thing I'd say is that even our beginning suggests how difficult it is to pull apart the constitutional questions from the political questions, right? And so if our thinking is murky about that, it's understandable because these things are clearly intertwined. And at the same time, one of the ways in which we reason through and interpret the Constitution is by precedent about what has come before, and impeachment happens to be, perhaps to our credit, one of those instances that we have rarely visited in our history. A number of us, quite a few of us, if I'm gauging the room correctly, actually recall the impeachment of President Clinton. I'm judging by the
youthful glow.
Yeah, the youthful glow. Thank you so much. Yes. And yet I would say, I think there's a caution, right, about turning to that instance as a place from which to analogize or reason. Yes, the president was charged with a wrongdoing, lying under oath. Yes, there was an important layer of partisanship that shaped the impeachment as it moved forward, but it is the Johnson impeachment in the Reconstruction era that I think is the better, more thoroughgoing analogy for us today. Now, President Johnson, in the early years of Reconstruction, is indeed charged with a wrongdoing. He is charged with violating the Tenure of Office Act, a technical offense. But when we look through the 11 elements of the impeachment, we see the way in which Congress then moves from that formal charge into what really is a battle between what sort of authority the executive is going to exercise over the future of the country, over the project of Reconstruction, the remaking of the nation after Civil War. Is that going to be steered by the president from the executive branch, or is Congress going to be the body that is really going to stitch the nation back together, reorganize it politically, constitutionally, and otherwise? And I think this is an apt analogy, or a useful analogy, precisely because my sense is that while we will approach this moment and the seemingly impending impeachment of President Trump by way of these technicalities, the deep subtext is a question about in what direction we are headed as a nation, who is going to steer us in that direction. And so we will make the technical arguments, but we will find it hard to avoid the profound, I think, and they're not simply political questions, I would say, right? They are moral questions, right, that also run through law and politics. And that, to me, means Reconstruction is a powerful touchstone for where we sit in 2019.
You speak powerfully about the precedent of Andrew Johnson. As you suggest, he was impeached for the technical violation of the Tenure of Office Act, but was acquitted partly because the act was thought to be and later found to be unconstitutional. But as you suggest, and as a guest on a We the People podcast we had on the subject also suggested, We the People is the National Constitution Center podcast where every week I call up a liberal and conservative scholar to debate constitutional issues in history and the news. And we did the Johnson impeachment, and Joshua Matt said the Johnson impeachment was brought on the wrong charge. It should have been the subversion of the constitutional promise of Reconstruction. The president's willful attempt to undermine the Reconstruction amendments was impeachable, even and a high crime, even if it wasn't a technical violation of criminal laws, and you're reinforcing that point. Reconstruction was clearly a constitutional crisis. And Quinta, you have written a piece for the Atlantic, a really debate-changing piece, Are We in a Constitutional Crisis? Tell us how you define a constitutional crisis and whether or not we're in one.
Right, and I wrote that piece a couple of months ago. I don't know if my answer might be different today. The thing about constitutional crises is that no one really seems to know what they are and what it would mean if you're in one or not. Keith Whittington has, I think, a useful distinction between crises that are caused by sort of where the Constitution sets up a problem and then doesn't provide an answer, and crises that are caused when there is a constitutional answer, but one or both parties doesn't want to abide by it, right? So into that latter category would fall the famous and probably apocryphal statement by President Andrew Jackson, John Marshall has made his decision, now let him enforce it, about a decision of the Supreme Court. That framework, I think, is useful. I don't know if it entirely speaks to our current situation. The terminology that I think is more apropos is constitutional rot, which is a term used separately by John Finn and Jack Balkin, both constitutional scholars. The idea basically being that rot is when the structures of the Constitution are all there. It seems on its surface as if it's working properly, but there's something that's falling through. The faith in the underlying principles is gone. And so we act out our fealty to constitutional structures. We elect the president, the Senate meets to advise and consent on nominees, but the underlying commitment to core constitutional values is in dispute or perhaps dissipating altogether. And I think that is really much more apropos to our current situation.
That is so well summarized. You helpfully remind us that Keith Whittington does have these two rather narrow definitions of constitutional crisis: a crisis of operational meaning, where it's not clear what the answers are, or where the branches literally break down because they can't agree or operate, like the Senate isn't funded or the Supreme Court has no members, or a crisis of fidelity, where the president says, I'm not going to obey the Constitution. But then you introduce this third category that Jack Balkin has noted of constitutional rot, where the formal mechanisms are respected, but the norms are being undermined. John, you are a great constitutionalist. You've been defending constitutional values valiantly in a nonpartisan way. Are we in a constitutional crisis, and/or are we in a period of constitutional rot?
Yeah, I couldn't disagree with Quinta more, actually. I didn't understand what her argument was, but now I do understand her argument. Look, there has always been tension, particularly with a divided government in a closely divided country, which we are, among the branches of government. When President Obama was there were fights with Congress and with the courts about Obamacare. There were fights with Congress about whether his DACA program was lawful. That fight still continues. There were fights between the executive branch and the president about getting documents for Benghazi or Fast and Furious. I mean, these tensions in a divided government exist. Nobody, to the best of my knowledge, has followed up on Andrew Jackson's threat at the time. Neither Andrew Jackson, in fact, didn't follow up on his threat. The only person that I'm really aware of was Abraham Lincoln, who after Dred Scott came out, said, well, I'm going to abide by the ruling in that case, but I'm going to continue to treat black freedmen as if they were citizens. So that was a certain amount of defiance of the Supreme Court. But President Obama didn't do that. President Trump isn't doing that. There are tensions. And if you throw into it the regulatory state, that adds another dimension to that tension. And we muddle through it. We muddle through it with fidelity and with legal arguments. And so far the courts have been respected. And I don't see any breakdown or rot that Quinta, it seems, sees.
Thank you for that optimistic defense of muddling through as an alternative to crisis. Martha, the historical perspective. There are certainly two periods of American history that everyone recognizes as constitutional crises: the Revolutionary War, which led to the original Constitution, and the Civil War. Others put different conflicts in different categories. Can you give us examples of the other constitutional crises you think America has experienced in the past?
So I'm going to come at it slightly differently, because we've begun by talking about Reconstruction, and it's important for me to remind us that the crisis for the Constitution that follows the radical remaking of equality and citizenship that comes with Reconstruction is very quickly undone, undermined by the U.S. Supreme Court itself. By 1873, slaughterhouse cases will be the beginning of a whittling away of the meaning and the force of the Reconstruction era amendments to arbitrate, right, a new democracy in the wake of slavery's emancipation. So here, it's a sort of crisis, because I would say that we then live through an era in which not all Americans, but many Americans have no confidence in the Supreme Court to be the arbiter of their lives, of their rights, of the Constitution and its amendments as they were intended when it was enacted. That we live through a long era in which the court nearly renders itself irrelevant. It's a period of social movements, right, where people from the ground up on the local level are themselves trying to breathe meaning into the Constitution, even against the ways in which the Supreme Court, Plessy versus Ferguson, of course, is the most notorious of the decisions of this era, that case that puts separate but equal into constitutional jurisprudence. Americans have to go somewhere else, right, to counter that. And I think today we might wonder if this court isn't headed to, if not rot, to a kind of irrelevance, right, for the kinds of critical human questions that are troubling us as a nation.
Thank you for that. You've written so powerfully about the history of citizenship. As you say, the whole point of the Civil War was to overturn Dred Scott's claim that African Americans had no rights which white men were bound to respect. Citizenship was inscribed in the 14th Amendment, but the Supreme Court undermined it, and you suggest that by making itself irrelevant and undermining its own legitimacy, the court may contribute to a sense of crisis. Quinta, I want to ask each of you, and then we're going to take your questions, what you identify as the fault lines in the current battle for the Constitution are. John mentioned the regulatory state, and I'll ask him about that in a moment, where conservatives believe that the federal government got too much power during the New Deal era, and that much of the regulatory state is unconstitutional, and they want to resurrect an originalist constitution that would constrain it. But Quinta, is that the line you would pick, or would you identify a different fault line in the current battle for the Constitution?
I think right now I The fault line that jumps out at me is to what extent we believe in or want to have the Constitution at all, actually. It's something really pre-political in terms of how we think about it. I've been very struck by the current political landscape is an interesting one. Just in a time of polarization, there are also many unexpected alliances. Certain people on the right are allying with certain people on the left on particular issues, often concerning presidential power. And I'm very struck by how the president and many of his more vocal supporters in certain areas often seem to point to a constitution that doesn't enjoy the same separation of power structure that we often think of. Trump has said, Article 2, it's a great thing, I can do whatever I want. I don't recognize the Constitution that I've studied in that, and so it strikes me that the real question is whether we want to maintain the existing structure of some kind of separation of powers and checks on the executive versus having a much more robust executive with relatively unconstrained power and perhaps moving toward a different constitutional project altogether.
Thank you for that. Because this conversation has been so good, I've been negligent in my constitutional duties as a moderator, and we have just about 2 minutes left. So for lightning round, final thoughts. John, what do you believe the current fault lines of the battle for the Constitution are?
I got to respond to a couple of things that Martha said, and then I will gladly respond to a couple of things that Quinta said.
But just quickly, what
I will.
the fault
So one is, I'm not so sure that judges should be deciding major social issues in this country. That is a major decision about whether that should be left to the people and their elected representatives, or whether 9 people in robes sitting on courts with, or should be making all of these social decisions for us. And two, one of the reasons why people don't respect the courts is because critics of the court fear that the court is going in a direction that they don't like, attack it. And they attack it saying that people are bringing their personal politics into their judicial decisions, and that undermines the legitimacy of the court, and that is extremely dangerous. I will agree with one thing Quinta said. I don't believe I've ever heard Donald Trump says that I can do whatever it is I want to under the Constitution. However, he cannot do whatever it is he wants to do under the Constitution. He has a large sphere of authority as the executive, but it is not boundless by any means or stretch of the imagination. One thing I find very curious about Quinta's statement, and you're teeing up about the administrative state, leads me to say this, which is that undue deference to the administrative state is all about violations of separation of powers. It is up to Congress to legislate, and it is up to judges to give their best interpretation of the law. The way things happen now is administrative agencies are given basically blanket authority to write the laws, enforce the laws, and then interpret the laws and apply them in particular cases. In other words, both legislative power and judicial power has been ceded to executive branch agencies. It has nothing to do with unwinding the New Deal. I might want to unwind portions of it, I might not want to, but it is all about separation of powers.
Thank you so much for that. Martha, last word for you. One brief, eloquent paragraph about what you believe the current fault lines in the battle for the Constitution are.
I think the debate is partly about whether the Constitution of 1787, as amended, is up to the challenges of our present day. I have been known to say, when it comes to the humanitarian crisis that is citizenship in 2019, that the Constitution, as it is written, is wholly inadequate, right, to addressing that and resolving it. On the other hand, Eric Foner has a new book out where he has really urged us to come back to the 13th Amendment, which abolished slavery, and the 14th Amendment, which guarantees many things, including equal protection of the laws. Foner is really advocating a return to that as a way of rehabilitating and making the Constitution relevant again. We'll see.
Thank you for reminding us of the relevance of what Foner has called the second founding, and for illuminating the stakes in our current battle over the Constitution. Please join me in thanking our panelists.